Across America, BP supports more than 275,000 jobs to keep energy flowing. Jobs like expanding capacity for biodiesel in Washington state and reducing operational emissions in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free. And catch up on the latest episodes without the ads.
Content warning, this episode contains discussion of the murder of 2 girls.
We always appreciate getting questions from listeners, and recently we have been getting quite a few about discovery.
This, of course, is the process by which the prosecution in a criminal case shares or turns over materials to the defense. But how exactly does it work? Does the prosecution have to turn over everything? Or can it be a bit selective? And what happens when a defendant changes attorneys before a trial?
To get answers to those questions and more, we turn to Timothy Sledd, the Chief Public Defender of Indiana's Lawrence County. In an earlier episode, Tim did a great job of walking us all through how the criminal justice system deals with mental illness. So we knew we could rely on him to explain the ins and outs of the discovery process.
Now, the questions around discovery that we received mostly pertain to the case of Richard Allen, the defendant in the Delphi murders case. He stands accused of killing teenagers Liberty German and Abigail Williams. But these questions are quite relevant to most criminal cases, and therefore we feel our listeners may find this information useful going forward. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet, and this is
a conversation with Chief Public Defender Timothy Sledd about discovery. Okay, Tim, thank you so much for coming on the show today. We wanted to talk to you a little bit about discovery issues. And I guess, can you tell us a bit about some of the discussion around discovery in the Delphi case and how you're sort of perceiving that?
Sure. Generally, so that the audience understands, discovery is the sharing of evidence. Just on a basic level, that's what discovery is. When an attorney represents an accused individual, just by way of the person being accused, we don't have the evidence that the state has. So there is in many jurisdictions, there's a local rule that expedites the sharing of information back and forth between the state and the defense. But there are also motions that can be filed through the trial rules that allow for one side or the other to ask the other side, hey, answer these questions or provide these documents and give us what you have. In the criminal realm, it's generally understood that the state needs to give the defendant everything they intend to use at trial. And that's something that in the Delphi case is going to be particularly interesting to see how that gets worked out. Because there's different ways that the evidence can be shared. It can be shared just in bulk, where you hear of terabytes of drives of every path the investigation may or may not have gone down, whether or not the prosecutor intends to use that at trial. Or it could be very more structured and tailored specifically for what is the evidence that the state intends to use at trial. The broader approach is usually the more prudent approach for a prosecutor to do. That way they don't have to deal with these Brady challenges. And Brady versus Maryland is a federal case, and it's a federal case that says that the state cannot withhold exculpatory evidence that may lend to somebody's innocence in a case. And so in my experience, most prosecutors hand over everything, the good, the bad, the ugly, the toad with the full warts on it, and they let the defense lawyer make hay of what the defense lawyers need to make hay of. In a case such as Delphi, where there's going to be such a volume of evidence, they could choose to be far more constrained in what they hand out. And one of the reasons they may be far more constrained in what they hand out is because there may be people that they zeroed in on or thought they were zeroing in on, but are factually innocent, completely proven to be factually innocent, and they don't want that person to be fleshed out as a potential suspect. The mechanism of discovery is how do we get evidence from the state to the defense, and then from the defense to the state in certain circumstances, in such a way that we have a fair and timely trial. Where there's a problem with discovery, the defense has several tools it can use. First, the trial rules provide a method of resolving discovery disputes. There's a trial rule called 26, and it provides in the subparagraph F that there needs to be an informal attempt to resolve a discovery or dispute. Usually a letter. In our office, we send a letter and an email to the prosecutor saying, hey, I read through the probable cause affidavit, or I read through the statement that was given, and it appears to me that there would be a body camera or a dash camera, or there was a statement by another person C, and we weren't provided that. Will you please provide us with that? And we give you a deadline to do that. Then if that fails, the defense can ask the court to compel, or the state could do this too, but the party asks the court to compel the other party to produce the specific thing. Usually a hearing is held on that, where the state can say, you can compel me all day, it doesn't exist, or it did exist, it's destroyed, or we don't have it yet, but we're looking into that. And then after an order compelling is violated, then the defense has the method of asking for sanctions to be imposed. And the sanctions can be, in the most serious of cases, exclusion of the evidence or the negative inference of the evidence that isn't given. So there's strategy that can be used through a formal walking the discovery down that path to where sometimes you can get evidence excluded so that the state can't talk about certain things that it may have or things it's heard or witnesses. But the defense can also, if something doesn't exist that should have been preserved and provided to the defense, then they can get what's called the negative inference from that. They can say, if we did get this, it would have shown that. Typically, that's why prosecutors, and from what I'm gathering, looking from the outside in, that in the Delphi case, they're using more of a, here's everything in bulk, have fun figuring it out, because we're having fun trying to figure it out, and then finding things that aren't consistent within there, or I can't even imagine the filing cabinets and within the Microsoft software, the folders and folders and folders, and having to go through and digest all of those would be just enormous for both the defense and the prosecutor. Because you got to remember, the prosecutor was not a special task force prosecutor. He's a local elected prosecutor who has to still prosecute his day-to-day possession cases, dealing cases, domestic violence cases. Throughout the pendency of the investigation, probably was letting law enforcement do its work. And now he's having to, I would imagine there were briefings, but now he's having to sort of become the case.
I'm curious, is it considered bad form for a prosecutor just to turn over everything in bulk without being labeled, as opposed to like sorting it out in some sort of index? Not
bad form at all. And I think it kind of comes down to what's the relationship between the prosecutor and the defense lawyer. There is no obligation that anything that is handed over be handed over in a specific format. Or in the county that I practice in, we have what we call a discovery portal. And the prosecutor receives the evidence from the law enforcement agency and does just a very brief organization, a very cursory organization. These are pleadings, these are officer by their number videos, and then they slide that entire folder, except for confidential information that they may have, work product, prosecutor may have identifiers of that they don't want to hand out yet, confidential informants, things like that. They slide that entire folder into our portal. We then grab it from there. And so it's often not organized how I would want it to be organized or have my staff organize it for me. But it's also, it's not the other where they've gone in and messed it up so that it would be harder for me to find. It would really surprise me if a prosecutor did that kind of behavior, because we're awful busy. And the prosecutors are awful busy. And I don't think there's a lot of anything to be gained by, that kind of chicanery.
I'm also curious, you talked about how some things might not fall under discovery. Mm-hmm. You mentioned, for instance, if, in theory, if I call in and say Anya committed a crime just because I'm mad at her, and they investigate her and find out she's totally not involved, that might not fall under discovery. So how are these sorts of determinations made as to what is discoverable and what isn't?
Well, the prosecutor is the first person that gets to make that decision. And the problem that sometimes prosecutors get themselves in is they make that decision too sweepingly. And then ultimately it's determined that, well, maybe that is Brady. And then there's egg on the prosecutor's face where the prosecutor wasn't necessarily really intending for there to be a problem. But they create the problem by saying, we're just going to hold this back. And in a complicated case where there's been years of investigation like Delphi, I would imagine that there were many different roads that were gone down in the investigation. And it's how far down those roads need to be shared with the defense in a specific defendant's case. And, it may be as simple as a summary report. One way that could be done is that regarding the FBI's investigation, there could be a summary report written up by the FBI that we looked into this, and none of those led to fertile ground, and end right there. Then the defense can always ask back and say, oh, really? You looked into this? Tell us more about that. And they can then pull that out if need be. Or you can just give them everything, including all the doors and the veins that leads into, and risk hay being made of any one of them, because the defense has to just find a reasonable alternative hypothesis to the case than what the state has and hang on that as being doubt that's reasonable. So in a complicated case, I would imagine that you could either do it in a summary report. Like if you didn't want to go down the path of, for example, in Delphi, let's say cults, let's say at some point in time, there was an emphasis placed on the occults and trying to figure out what those are. Let's say they rule out occult A, occult B, and occult C, but they don't rule out occult D till much later. A summary report on why those got excluded or that they did get excluded might suffice for discovery purposes, because it's not evidence the prosecutor is going to use at trial. In fact, to the contrary, it's evidence they know they're not going to use at trial, nor does that evidence speak to the guilt or innocence of some other accused individual. But yet a notation of it would most likely need to be there so that if the defense wants to pull from that and to learn more, they can. In more garden variety, day-to-day investigations, prosecutor most likely is just going to give over everything, every witness statement, even if it's wrong, because a deposition can be taken of that witness to determine why they perceive something. So in the case of you hear of an investigation and you've got some sort of axe to grind on Anya, and you call in to the tip line, and they then investigate Anya, they're going to say, we found out she had an alibi and that the reporting source had motivation to lie.
Thanks, Kevin.
Got you in trouble for nothing. We talked a bit about Brady. Can you go a little bit more into detail? What's a Brady violation? What sorts of things that involves?
Yeah, so a Brady violation, I guess let's start with the easiest Brady violation. Let's say somebody else confesses to a crime, but the investigation holds that back. They continue to do their investigation. Maybe they don't believe the confessor. Okay. There's a lot of value judgments that investigators are making. You have a hypothetical murder, and it's a whodunit type of murder, and somebody confesses, but the police don't believe that person. They don't, for some reason or another, they don't attach a whole lot of value to that confession. And they continue their investigation, and they arrest somebody who becomes the defendant. If they say, well, this person A confessed, but we don't believe him, and we're going to charge person B. Person B is walking up to trial. Brady is a trial right. The state doesn't have to disclose that unless a reasonably prudent person would believe that it would attack a piece of evidence. And so, of course, I believe they should put that confession in as soon as possible, because that's clearly somebody else is out there. It's a piece of exculpatory information. And if person B has not confessed, or there's a circumstantial case, that confession's highly relevant, should be shared. If it's not, that's a Brady violation. And Brady violations are very severe in the sense that where it's determined that there's been a Brady violation, most often there's a new trial that's granted, and you start back at square one with that piece of information. There are things that can make what would seemingly be a Brady violation not a Brady violation if specifically in the circumstance of a false confession, or a confession that's determined not to be reliable, and the defendant that you have makes a reliable confession that has indicia of reliability that are far greater than and is met by other corroborating evidence. They may throw out and not even submit in discovery that other confession. However, good prosecutors most likely will take any confession that's put inside of a case, even if they find it not to be reliable. They will take that confession and they will have a report written on that, or ask for a report to be written on that says this confession was received. We know it not to be reliable because of this. Provide it to the defense. Let the defense track that down and chase that down. Brady violations they're still things that are addressed. In Indiana, we have the Lyons case, Lyons case that just came down this year, and it was out of the county that I practice in. And what it was the polygraph examiner made changes to the form that the defendant filled out before giving the polygraph exam, and didn't tell the defense or the state that happened. That piece of information is critical because the defendant thought he was walking into trial with one piece of evidence against him, and in fact, there's a completely different strategy that gets put in there if it's not a stipulated, or if it is a stipulated polygraph exam. So, because the defendant was surprised on the eve of trial with that, it was the judge heavily sanctioned the state, excluded the evidence. It went all the way to the Supreme Court of Indiana this year, and they found that was a violation of the constitutional rights because of discovery.
Here at the Murder Sheet, we work on the podcast and our investigative reporting full time. That means we sometimes don't have time to meticulously plan and cook delicious and nutritious meals. So, in this new year, we are eternally grateful to our sponsor, Factor.
Now's a great time to try out ready-to-eat meal delivery service Factor. Remember, when you support our great sponsors like Factor, you're supporting us and our ability to keep doing this work. So please consider visiting factormeals.com/msheet50 and use code msheet50 to get 50% off.
Factor allows you to pop your ready-made meal into the microwave. In 2 minutes flat, you'll have a hot and ready dish with minimal cleanup afterward. It's just that simple.
Also, this food is awesome. I recently dug their black bean and rice enchilada bowl with roasted zucchini, corn, and salsa verde. It tasted so fresh and flavorful.
I love that we get to skip meal prep, the grocery stores, expensive to-go orders, and elaborate cleanup. Plus, there's plenty of options for extra picky eaters like me.
We've really been thrilled with Factor, and we feel you will be too if you're striving to eat healthy and save time in 2024. It's really helped me meet my nutritional goals for the new year.
head to factormeals.com/msheet50 and use code msheet50 to get 50% off. That's code msheet50 at factormeals.com/msheet50 to get 50% off.
We talked a bit about the consequences of Brady violations. When we were researching one of the figures in the Delphi case, namely Judge Francis Gull, who of course is presiding over it right now, we found one case where in Allen County, the press characterized her as throwing out a murder case because of discovery issues. Essentially, a man had been murdered in a Subway restaurant, and they honed in on one person. Then it turned out another man had robbed said Subway restaurant in an armed robbery like a month before the murder. And I guess that was kept out of things. And then recently there's actually been an arrest of a third man who, I guess has even better evidence for. So I don't know, really getting away from just that specific case. When it comes to throwing out a case effectively over discovery issues, is that something that you've seen a lot of, or when that happens, how wrong do things have to go for that to happen?
Not surprised that a Subway case and Judge Gull struck your fancy murder sheet and your restaurant murder.
Got it.
So I have never seen the court throw out a case. And only one time in my professional career have I seen a judge dismiss a case where the state didn't move for it to be dismissed. And that was because it had to happen as a matter of law, because the person had their competency restored and they had been incarcerated and then inside of the mental health department longer than the maximum sentence for the crime for which they were charged. So just so that the audience is clear, it strikes me as judges don't get to throw out cases in their entirety, but for a couple different situations. And those are very, very rare and very hard. What they can do is they can exclude necessary evidence for the state to be able to proceed and cause the state to have to dismiss the charge. Now, there are, if you blow certain timelines like CR4, Criminal Rule 4, or the Fast and Speedy, then there are times where a case must be discharged and a judge would have to do that. But very seldom have I experienced that occurring. And there are so many loopholes and methods through and around those timeframes. Now, as a sanction for a Brady violation, I think more frequently what you would see is the court saying, state, you should have done this, you didn't do this, therefore you can't use this. And to the defense I'm going to allow the defense to instruct the jury that there's a negative inference that can be gained from this evidence not being preserved or given to them in time. And then the state saying, well, we no longer believe we can make our case, and having to dismiss. Most prosecutors don't give up murder cases for dismissal lightly. They'd almost rather try it and lose than let somebody just walk out the door without the trial. But they have ethical rules they have to follow too, and they have to be able to get past that bar of the directed verdict. If they don't have a piece of evidence that they need, then they're just left to ask for it to be dismissed. But as a sanction to the state dismissing their case, I've never seen that happen. Very well may have, though.
Yeah, I may be misremembering certain details, or at the very least, I know the case was. It did not. The trial did not occur, and I don't know whether that was essentially her throwing it out. That's again how it was characterized in the press, but it very well may have been her excluding specific important evidence, and then the prosecution walking away. In those days, Allen County seemed to be having a lot of problems with the prosecutor's office doing discovery violations and Brady violations. So I know there was like some sort of mandatory training that happened, at some point around this time, where it's like, let's learn how to follow Brady.
Yeah.
I'm curious a bit about timelines of discovery. If in theory I'm representing Anya for some terrible crime she's committed, obviously I can't go into court and like the night before get a truckload of discovery dumped on me. How long before a trial is the prosecution or the state expected to turn over discovery materials? That's
controlled by either the trial rules or local rules. And so it can be different even among the 92 counties, and I believe there's only 91 court jurisdictions, even though we have 92 counties. So in the county that I practice in, we have a local rule. The appearance of a defense lawyer triggers discovery deadlines for the state of Indiana to produce documents and items of discovery evidence. So in the county that I practice in, you would have a recourse if on the eve of trial you received a truckload of evidence, because that would be well outside of, even if you had filed for a fast and speedy, it would be well outside of the deadlines of the local rule here. And so it would depend upon the community where the case is being charged if they have that local rule. Even if they don't have a local rule, if you, as a competent defense lawyer, filed a motion for discovery, you now trigger the trial rules and the deadlines that are in trial rules. The state has the responding party to a motion for discovery has a time frame in which to respond. It doesn't mean they have to complete discovery within that time, but they have a time frame to respond. Then the rule of 26F, where there's a discovery dispute between the parties, you would have to seek to answer that informally or address that informally. You could do it by way of a letter, an email. I guess you could have a conversation, but if you're having a dispute regarding that, it's probably better to have it in writing. And you can put whatever deadline you want on that, but then you file the motion to compel. Court will give usually 30 days after an order to compel, and then you have a hearing for sanctions after that. In some cases, and I guess the other way of looking at this is the judge is going to be the one that decides what's a reasonable time for evidence to have been exchanged. In a traffic stop possession of methamphetamine case, a judge is probably going to have a very short tolerance on the state for disclosing evidence. I mean, it's a traffic stop. We probably have a body cam. We probably have maybe a dash cam. You have the pictures that were taken of whatever was gathered. You have the request for the Indiana State Police Lab to do their analysis of the stuff. And then that's probably where you're going to stop with discovery for a while, because that lab process has to happen. And then the state has a duty to give you the lab results. And so the turnaround time on evidence for that sort of case, you would imagine a judge is going to say a very short turnaround time, except for the lab results. You may get the lab result. If you file for a fast and speedy, you may get the lab results on the night before trial, but you asked for the fast and speedy. If you're 9 months out and you're getting ready for trial, you'll probably file a motion in limine or something to cause the court to say, hey, state, you're not going to be allowed to use this unless you get it done. And I know that the lab expedites its work based upon trial deadlines. So, a garden variety level 6 felony methamphetamine is not going to be processed unless there's a trial looming. Now, on a case that there's more to it, the judge may say, no, the state needs more time, and we're going to give the state more time to give you the evidence. They have to have, you can have a bond hearing or a preliminary hearing to weigh probable cause. If they don't have the evidence that their probable cause says that they do, that it doesn't exist, or you think that needs to be reweighed, you can have a hearing on that. But the state may say, hey, yeah, we're waiting for forensics to come back, or we need we have to have a phone dump completed and analyzed. There's many different things that could go outside of what would be a normal, 30, 60, 90 completion of discovery. But your garden variety case, things get turned over pretty quickly.
I was curious, just from a practical standpoint, you've been on the prosecution side, you've been on the defense side. How does one manage, review, organize, and sort of really sort through a mountain of discovery in cases where there are a lot of discovery, I guess on both sides?
Mm-hmm. The state has the benefit of its investigators have been immersed in whatever investigation they've been in. And the state has the benefit of relying upon their interpretations. A detective comes in and has, let's say a terabyte drive of evidence, and can look at the prosecutor and say, hey, I think you need to charge this crime that I believe happened here, and here's why, and can summarize that. And here's on this terabyte drive, you're going to see the evidence that supports that. and the prosecutor can charge that case up without having digested all of that. Maybe not the best practice, but if they have a good working relationship and years of experience together, and there's an availability for them to rely upon each other, then, I've seen that happen. And then they start to say, okay, how am I going to organize this in preparation for trial? The defense is behind. The defense is late to the game. Probably in the public defender world is going to be not staffed the same way that the prosecutor's office is with, a full agency or many agencies that can digest and organize the material. So from a pragmatic standpoint, I have an investigator, and she also doubles as my paralegal as well. But when she pulls the discovery down, she is processing through it. I'm often processing through it at the same time, especially on the bigger cases. We're digesting those things together and trying to organize the file and figure out what we do and what we don't have. A good starting point is the probable cause affidavit to see what did the officer believe the evidence that they've acquired, which is most beneficial to them, says, and then what questions does that raise for the lawyer, and where does the evidence show, and where doesn't it show, and what's missing. In the age of body cameras, in most police citizen encounters, you can get a pretty quick shot of the truth by looking into that. And in longer investigations or whodunit investigations like burglaries or auto thefts or anything like that, then you want to say what's the thread between the accused and the accusation. But it can be in a situation where, say, for example, in the Delphi case, where the defense is being handed just the volume of 7 years of investigation, probably step one would be to organize things into statements, reports, videos, photographs, and just get those things all organized into basic folders, and then start to delegate and digest. In big cases in my office, we use a team approach. So there will be at least two lawyers on every major case. And we have team meetings with the paralegal and the two attorneys where we say, this is how we're delegating the tasks. And then we put together the path forward on those cases, whether it be strategy or procedure.
One thing I was curious about is in the Delphi case, we were interested to see the old defense team, Andrew Baldwin and Brad Rosie, when they're talking about the discovery at some point, at least in their Frank's memorandum filing, they would be mentioning that, they weren't getting some things from prosecution, although there would be at times almost a subtle acknowledgement that they may have gotten them, but they may have just not found them yet. Is that the sort of like back and forth maybe? Can there be a bit of sniping between defense and prosecution over discovery like that, where there's a lot to go through, things are not clear? Or is that a little bit unusual?
It can be common for the defense and the prosecution not to agree on what discovery needs to happen, and not be happy with the time frame of discovery. And a lot of that's guided by your judge. The judge will often sort of set the expectations on, what's happening in the world of discovery. What is sort of abnormal about the situation that you referenced, though, is that when you take a shot at another lawyer in court or in a court pleading, you really want that to be able to be backed up, because it's important that your professional integrity be able to fly. And if I say that I haven't received something that I have received, and I don't couch it in the language of, well, maybe I did receive it, but I haven't looked, that's bad. You need to know what you have and you don't have. And I understand I'm not sitting with 7 years of investigative materials dumped in my lap, but if I'm going to really say that, I'm going to be cautious not to be throwing the prosecutor under the bus for that. Or if I'm throwing the prosecutor under the bus, I better be sure it's not there, because if they show it, then it chips away at the integrity, and the court's not going to view the discovery complaints in the same light. And I can think of a case in my practice, and even recently, where I claimed that I didn't receive something, and I didn't have it in my file. I was sitting in court looking at my file, and I didn't have it. And the prosecutor spins his laptop around and points to a folder that shows that I did have it. Well, I did have it in the offices, in my office's system. It hadn't been downloaded into my files. And so there was ships passing in the night sort of thing. And I ate a good amount of crow in apologizing to the state. But at the same time, as the judge saw there was a delay, and it was a delay in getting it with the other evidence that I had. So, but to that end, it was a lesson for me to just take a deep breath, make sure I know everything I really have, and I now send a message to my investigator. We check the portal, make sure nothing new's been added. But all of this is to say that the system does not want trial by ambush. The trial rules, the criminal procedure rules, local rules relating to discovery all envision that everybody should know what the evidence is long before we get to the trial, where we get to argue about what evidence comes in and what the evidence means. That's large. Trials are meant to be a discussion or a dispute about what evidence gets to come before the finder of fact, the jury or the judge, and what does it even mean? They're the Matlock moments, which Matlock's what my parents and my grandparents watched. And most of your audience probably doesn't know that, but the sort of surprising things in a trial aren't surprising because the evidence hadn't been shared back and forth. It may have been because somebody didn't look at it, or somebody didn't digest it right, or an interpretation of it wasn't made in a particular way. But nobody ever walks in through the doors right before a closing argument and says, "I did it," or "that person's, I saw him do it," or whatever. I mean, that's not how it happens. And the discovery rules are meant to be that way because at its core, the purpose of the trial is to get to the truth. And over 225 years of jurisprudence, of court cases, of procedure, have sought to say this stuff is reliable and this stuff isn't reliable. So we'll allow this stuff to come in at a trial and we'll exclude this sort of stuff out of a trial so that we get to the cleaner picture of true. And we also then have the burdens of proof. And that's because, again, we're dealing with a governmental entity and citizens.
Really well said. And yeah, we always tell our listeners that, this stuff should be boring and not, hopefully we can convey it in an interesting way, but it's not, you're not every Law and Order episode, there's some massive twist, and they got them to confess on the stand, or they, broke down and started screaming at the prosecutor, revealing themselves to have like an anger issue. And it's like, it just gives people such a wrong idea because then they don't know what to make of it when there is no twist and it's just like a pretty, rote procedure. Mm-hmm. But yeah, it's important.
Yeah, and also to that end, the strategy of the prosecutor and the defense never has to be shared. Often you pick up on it. Sometimes it's as obvious as it being daytime or nighttime outside. But the sharing of a complete strategy or the forcing of the sharing of a complete strategy never has to happen. So there is a little bit of suspense when you go into a jury trial as to what are they really going to hone in on. In the civil world, you have Trial Rule 16, which requires the parties exchange final witnesses and exhibit lists, stipulate to certain facts prior to the trial. So you already know marked exhibits. I mean, in the criminal realm, we don't have that Trial Rule 16, but judges will often issue what's called a trial order, where they will say you need to work together to stipulate to certain facts. And you can have it. You do have a right to a final witness and exhibit list. So in our county, the first discovery compliance that we get from the state of Indiana is sort of a blanket statement. It says all people listed in the probable cause affidavit, all reports that may have been produced, and it doesn't tell you anything. The state has to clean that up before we get close to trial, so that I know actually who's coming, who's going to show up, or who, and they can ultimately on the day of trial decide not to call somebody, but they have to narrow it down.
And then we're in a really weird situation with Delphi, obviously, because as of right now, there was an original defense team, Bradley Rosie and Andrew Baldwin. Now there are some new defense attorneys coming in, Robert Scrimmen and William Labrato. I know that in her comments to the court, Judge Gall indicated that she expected the original defense team, the old defense team, to pass on discovery to the new defense team. When you have that sort of handoff, is it typically between the two defense teams, or does the prosecution have to get involved to make sure that everything is handed over?
So in my experience, and having taken over cases for prior counsel before, you typically get the evidence directly from prior defense counsel. Then it's best practice to set up a meeting with the prosecutor's office and do a cross check. Not because you think that the prior counsel did anything, but if the defendant is the one that has the right to the discovery. So a frustrated or taxed prosecutor can look at the court and say, I gave that defendant all the evidence when it gave it to the first lawyer. And so if the second lawyer says, well, I don't have it, and there's a receipt showing that it was sent to the first, well, that's not on the prosecutor. It's not on the state. There's no remedy to the state. So when I've taken on a case that somebody else had before, I look through the evidence. I get it organized in my way, and I put together a list of the items, and then I go to the prosecutor and I say, hey, I want to sit down with you. I want to go through this evidence just to make sure I have everything. And usually it's a check. Everything's there. You're good to go. And you can do that in such a way that doesn't play any hands toward strategy or give up any attorney-client confidence, because it's just acknowledging what has and hasn't been received. Most often, that's how it's done. It's done from defense to defense, where the judge, as in the Delphi case, seems to have lost confidence in the ability of the prior defense team to manage its documents. It may say, no, you're going to get all of your evidence from the state, and the prior defense team has to give it back to the state. And so everything's going from one channel. That way, subsequent counsel can't sort of point to whatever was happening in the prior group's digestion of that material to say, well, we were thwarted from actually doing a good defense for the client because we were basically eating the chewed cud of the other team. We want it fresh, and I want fresh eyes on it. So Goal sending it to McClelland and then saying, hey, McClelland, you're going to give it to the next counsel, and we want the old counsel to still cooperate, because who knows what they may have done with it. They may have been preparing exhibits. They may have been preparing charts. They may have been preparing things that would benefit Richard Allen. I mean, Richard Allen's defense was being created by these folks, and it's still his defense. And if it's going to facilitate the next group so that they can hit the ground running, it sounded to me like she wanted them to cooperate, but she wasn't letting the state off the hook by saying, yeah, you've already divvied it out. Divvy it out again.
I just have one quick final question. Near the beginning of this conversation, we were talking about discovery, and I think most lay people think of discovery as being a one-way street from prosecution to defense. Mm-hmm. And you alluded to the fact that there are some occasions where the defense has to turn over materials to the prosecution. And I was just wondering if you could discuss that.
Sure. Again, a defendant has a Fifth Amendment right to remain silent and does not have to produce any evidence, call any witnesses, doesn't have to do anything but stand back and say, prove it. So very seldom is there going to be anything sent from the defense back to the state. However, there may be times where there's been an expert hired, where there's been an independent analysis of something done that, and there's a report that goes along with that, where there's a witness that has come forward and will testify on behalf of the defendant in some way, shape, or form. The state has the right to be on notice of all of that. Now, certain defenses have to be raised early and loudly, and there's actually a burden that goes to the defendant to to meet certain things, such as insanity. Where an insanity defense is lodged, the defendant has the burden of proving insanity by a preponderance of the evidence, and then the state has the burden of disproving it beyond a reasonable doubt. So there's automatically going to be an exchange of information related to that. Sometimes the witness list for the defendant will be people that are also on the state's witness list. I mean, there's the gray, and the gray there's black, white, and gray, and the gray witnesses sometimes get listed by the defense as well. But it is not very common that there is a large exchange from the defense back to the state for the accused, unless there's some sort of science issue or other witness that has an alternative theory that they're willing to go into court and testify about, because typically the state has ironed that out, or their witnesses will be able to be had on cross-examination to elicit or elucidate those points. And another strategy for the defense is that cross-examination is a much richer way of exposing holes, flaws, miscalculations in the state's case or with the state's witnesses than direct examination. And so if a defendant holds back on a witness or has a witness that the state isn't going to call, that they need to call, they have to know that the prosecutor is going to get cross-examination of that person. Cross-examination often is the narrative of the lawyer with the simple answer of yes or no from the witness. So the lawyer is testifying and the witness is agreeing with their testimony. A good cross-examination often feels just like that. And juries like to hear the lawyer's answers. And then, of course, lawyers who already know it's predestined what they're going to argue in close argument. They're building that map toward, good trial lawyers are building that map toward that final thing. And so if they can get person A to say yes, but the yes is to, it was a red truck with, great big tires. Well, ladies and gentlemen of the jury, you heard, witness A say it was a great big truck with big red truck with big black tires. The person didn't say that. They said yes to it, but the closing argument was made. So, cross-examining, is off. The defense has the ability to cross-examine the state's witness and get all of that done versus have their own come in and be subject to cross-exam, especially the defense goes after the prosecution. So the state case, state rests, defense goes, and any witness they call gets cross-examined. So the prosecutor gets the opportunity to be orating the facts with yes/no responses. The state can then call rebuttal witnesses if necessary, if they weren't able to clean something up. But then they go into closing arguments. And closing arguments, as you both are aware, is the state goes, the defense goes, and the state cleans up. So it's because they had the strict and heavy burden, they get that opportunity. But there's a lot of strategy and calculation to that. And one way to address that is through like depositions, is having the depositions done.
Is there anything we didn't ask you about, Tim, that you wanted to mention about discovery, or you think it would be important for people to understand this, somewhat complicated subject that seems to differ a lot depending on the case, but also we have these kind of rules that need to be abided by, just to help people understand it a little bit better?
I mean, I think just to summarize is that discovery is legal procedure. It's, even though there's still room for litigation within the practice of what is the right discovery, or, what is a Brady discovery violation, or what is a sanction for a discovery breach. It's largely what lawyers do, what trial lawyers, what prosecutors and criminal defense lawyers do. In every case, we're doing some level of discovery, some level of sharing of the evidence. And so, as sort of tantalizing as it might seem, it's probably a pretty boring process, and very seldom is it the is it the aha moment in a case? And ultimately, you don't want it to be the aha moment in any case, because that means lawyers messed up a case versus, the facts not bearing out. If good lawyers, prosecutors or defense lawyers, are analyzing the evidence right, the case should proceed in its terminal path very smoothly. It doesn't mean there's not going to be suppressions. It doesn't mean there's not going to be arguments or a jury trial or the things that go on. But having sidebars or side hearings on sanctions and things like that, that's not the life of that's not the right track for a case to go. That means there's been, that's taking away from the issue. The defendant is probably sitting incarcerated during that period of time and not having their case progress toward trial or in the sense of the Delphi case, I don't know if you can call them facts of the case or the evidence of the case, or at least the theories of the case are being litigated even before we get to the opportunity to have a jury hear them. And so, the discovery is meant to allow for the lawyers to be able to prepare for the trial and to know what each side is going to have and be able to use. So, if you have any other questions about that.
No, do you have any?
No, this has been very helpful. This is incredible. Thank you so much.
Thank you so much, Tim, for your expertise and sharing it with us and our audience. We really, really appreciate it.
No problem.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.